Can everybody hear me?
Yes, Your Honor.
One second.
Hearing.
Sorry.
The Court of Appeals of the 14th District of Texas is now in session. Pursuant to adjournment, God save the Constitution and so on the court.
All right, good afternoon. We've got case number 14-19-00591, Hart v. State. Everybody ready to proceed?
Yes, Your Honor. Pat McCann for the appellant, and my colleague, Ms. Julia Bella, who will handle rebuttal.
Okay.
Yes, Your Honor. Heather Hudson for the state, present and ready.
All right, and I see by the timer on the screen that you've reserved 3 minutes for rebuttal. Is that correct?
Yes, Your Honor.
All right, you can proceed when ready.
Thank you. First, let me say that it's a pleasure to be doing the first Zoom argument that I've had. May it please the court. My name is Patrick McCann, and I'm here today to represent Robert Hart. Mr. Hart was convicted of murder in the court below out of Harris County and sentenced to 30 years. We brought 3 issues on appeal. In the interest of brevity, I would like to argue what I believe to be the 2 strongest today. The first of which is the, to my mind, inexplicable refusal by the trial counsel of an offered sudden passion instruction at punishment. And the second is the extent and proper prism in which to view consent. Going to our first point, during the punishment, the charge that was to be given by the trial court included a sudden passion instruction, which, as the court knows, if the jury finds, limits the potential punishment from 2 to 20 years. The trial judge, in talking with the parties, offered this because he obviously thought that it was merited. When the defense counsel heard this, he turned it down and said that he did not believe that he was entitled to it. And the trial judge expressed some surprise, I think, in his response, and then took it out. In this case, that is ineffective assistance of counsel. And I find myself in the position, I can only analogize to the sheriff of Harris County when he discovered that the chief investigator in the Goforth deputy killing had been sleeping with one of the witnesses, and he had to say in a public news conference, I didn't think it was necessary to make this rule, but one can't sleep with the chief witness. In this case, I have never seen a favorable instruction such as this. And please, if the court would keep in mind, this is the only favorable instruction available anymore in a murder case. There's no more probation instruction, even from a jury. There's nothing else that could have limited his time, and the jury had made the decision to convict. So there's no downside whatsoever, no potential harm, no trial strategy for the defense counsel to justify turning this down. And when the jury came back with a 30-year sentence in a case in which it is extremely clear from the facts that they were denied an option to consider and express whether or not this was actually a result of sudden passion, I point the court to the voir dire, which did not cover in any way by either the trial court or the parties the possibility of sudden passion or any of the law regarding that. The only way this could have come was from the instruction. And denying that instruction, in other words, turning it down by the defense counsel, denied the jury a vehicle to help his client and to get them to a place where they could do his client some good, or he could limit his client's damage. Under Strickland, this was below par professional performance. Under any prejudice analysis. The prejudice is clear. It's an extra 10 years off his life that Mr. Hart does, frankly, at his age and in his health, does not have to give. And in this case, Your Honor, it is a clear, unequivocal act of ineffective assistance. Simply turning down a favorable instruction like this, there's no way to justify it. There's no possible trial strategy to let it somehow go unchallenged. And so we offer that as a Sixth Amendment problem to the court. We also take on the issue here of the extent and scope and prism through which this court should view consent. And we want to put the court in the frame of mind of Mrs. Hart, who signed the consent. She was in the backseat of a patrol car. Her husband was facing a potential charge and had just killed a man. Her daughter, her youngest daughter, she had no idea what was going to happen to her. And her older daughter had just been traumatized and witnessed the death of her ex, or abusive ex, and the potential loss of her father. In that circumstance, I don't think that there was in any way a clear, involuntary and knowing consent. But even if one could get past the emotional state, which by the way was testified to by the constable deputy, not the defense. If one got past the mind state of Mrs. Hart, you are still looking at the scope and extent of the consent, and that general consent form did not cover electronic devices, recording devices, digital information, anything that, for instance, if you were to now seize a cell phone, one would be required to get a warrant for. So in that sense, the consent form itself does not go far enough, and the person consenting did not have the state of mind to author those folks to go in and do that, and to fail to get that raised, especially when you look at the fact that the state delayed getting this information to the trial counsel. It means that this counsel was ineffective. He was ineffective for failing to ask to suppress this, because if you look at the prism of the law, it is the state's burden, once consent is raised, to make it clear that consent was knowingly and voluntarily given, not coerced. And I don't think you can do that here when you look at the underlying facts. I think the state would have had a very hard row to hoe, and it would not have succeeded in proving that burden.
Counselor, can you kind of lay out for us what the state did bring up to try and prove that, and also what your factual basis would be on the other side as to what the defense attorney should have argued?
The defense attorney should have argued, Your Honor, on and I'm assuming you're talking about the extent of the consent or the consent form itself.
Yes.
The state attempted to basically rehabilitate their own witness. The female deputy that testified, clearly said that Ms. Hart was, basically a basket case beside herself for all the reasons I'd mentioned earlier. They then took a break, and she came in and on redirect said, well, she was coherent enough to, review the form. I think they realized that they had stumbled on that and tried to correct it. But this is where the defense counsel's responsibility comes in. Mrs. Hart was available. She testified at punishment. She was there. Now, there is always the argument that, you couldn't trust the reliability of a particular witness for trial strategy. The problem is that he obviously trusted her enough at punishment. And frankly, if she had demonstrated the kind of emotional angst and distraught that she had at the time, I think the jury would have seen what kind of a person she was in terms of, the strength of her disposition and her calm under pressure. This was a woman who had gone through an emotionally battering experience and was in ill health in the first place. She walked with a cane even then because there was testimony about that when they put her in the patrol car. So had the trial counsel simply brought her up to reinforce the fact that she was not able to understand this, I think you would have had a clear victory, because the only people that would have been there would have testified to her mental state. And as to the form itself, I leave that to the court's discretion. It is a broad, very broadly worded form. It is not specific. And as the court knows, consent must be specific as to each and everything that is searched. In other words, I can withdraw consent at any moment for a particular room in a house. I can withdraw consent for contents of an item, a chest of drawers, a purse in the house. I can withdraw consent for the curtilage or the garage. So to have a deputy go in, start playing with, and then fixing what apparently was a malfunctioning recording device, and then playing that without getting a second consent form or a warrant, I think is a violation of the extent of the consent on this. So I think on the two prongs, both the state of mind of the person who gave consent and the scope of the consent itself, counsel failed to challenge this, failed to meaningfully go after it, and fell down on the job. And I do not enjoy raising these claims on direct appeal, because I know we'd all like more, but in these cases where we have clear factual basis for the record, I think it's very apparent as to the failure. I see my time is running down. Does the panel have any further questions? Then I will yield my time, and I will urge the court to reverse and remand this back for either a new punishment proceeding or a new proceeding and trial. And I thank the court for its time.
All right, thank you, counsel. We'll switch screens here. All right, you may proceed.
May it please the court. In response to the first argument raised by opposing counsel, I would have to quibble about his characterization that the trial judge was offering a sudden passion instruction. If you read the record, the trial judge makes it clear that this is a proposal and just a proposal. And then I would also just, with all due respect to opposing counsel, I would again urge this court to overrule this issue as inadequately briefed, because the appellant's brief doesn't specify which theory of sudden passion they're pursuing. They don't state if this is extreme fear or terror, or if this is rage. And they make the assertion that there's evidence to support a sudden passion instruction, but then fails to offer any analysis as to what that evidence is, which puts the state in a rather awkward position of essentially having to construct an argument on the appellant's behalf and then attack it. I would argue that under...
I'm sorry, when you're quibbling about whether or not the court offered sudden passion, when you're saying that, was it part of the court's proposed jury charge?
I don't know, Your Honor, because the record doesn't reflect that, but I don't think that a trial judge essentially asking defense counsel if he wants a sudden passion instruction would indicate that he's entitled to it. And that's what should be of significance to the court, is whether or not he was legally entitled to it. And my argument would be that under either theory, really he's not able to establish ineffective assistance in this case for failing to seek it, because I just don't think he's going to be able to get around the prejudice prong of Strickland, which is something that he has to do.
Well, if we're trying to determine whether or not trial counsel was ineffective for not asking for or receiving a sudden passion instruction, wouldn't that necessarily also kind of by extrapolation mean that trial counsel didn't present or didn't highlight evidence for sudden passion? Wouldn't that all kind of be encompassed together?
Well, I'm not exactly sure what you're asking. I can't speculate as to what potential evidence there may have been that would support sudden passion. But again, that would be the appellant's burden to have a record that's sufficiently developed to show that there was some additional evidence that could have been presented, but that wasn't. And the appellant doesn't show that here. So all we have is what's on the record. And I don't think that what's on the record is sufficient, primarily because it's the appellant's own surveillance footage, which essentially just completely destroys any claim that he was entitled to an instruction on sudden passion. I don't know if the court has had an opportunity to review that footage yet, but if you haven't, I would urge you to watch it because, essentially, if they're proceeding under the theory that the defendant was so afraid of the victim, all it takes is for the jury to go ahead and watch that video, and they can see, the victim essentially just pulling up outside the defendant's home, taking off his shirt and smoking a cigarette. And then you can see in the video, the appellant really marches out there to confront him. He's holding a gun. He walks right out into the street up close to the victim, points the gun straight at him. Then you can see the victim holding up, both of his hands, which are empty. And the appellant just proceeds to gun him down and continues to shoot at him as he is trying to flee behind the car. So
the video doesn't show the history between the appellant and the complainant, does it? It's just the scene of what happens outside.
It is just showing the scene of what's happened outside. But I think even if you're looking at other evidence and just taking it as true, like I believe there was an allegation that the victim had at some previous point showed up at their home and pulled a weapon or something. I still think if you combine that with the evidence of the victim's actions at the time of the murder, the video is just still going to, I don't think any rational juror watching that video could find that, yes, this defendant was acting under such extreme terror and fear for his life that he was rendered incapable of cool reflection. Because you watch the video, I think you can see someone who is angry, not frightened. He goes out there to confront the victim. It's clear from the video the victim's unarmed and he guns him down. And then it's not very long after the victim, collapses and hits the ground that you see the defendant walk over, take a gun out of his own pocket, fire it, and then place it in the victim's dead hand.
So did the state present any aggravating circumstances at punishment? Or did they rest on the evidence presented at guilt innocence?
The state rested on the evidence presented at guilt innocence.
And was there any evidence during guilt innocence to rebut this, assertion that the appellant and the complainant had some altercations in the past?
If I recall, the only evidence was testimony, I think, from one of the other deputies that there had been some sort of an indication where the police were called out, but that they weren't able to determine who was credible, so nothing really came of it. And then, of course, I believe there was testimony that the defendant was abusive towards the daughter. So again, I focused on my brief on whether or not the victim's actions were sufficient to provoke extreme anger or rage. And I still think under these circumstances, even if you look at evidence of all of the, bad things that the victim did, and showing up, presumably to provoke the defendant by showing up there at his house. Obviously, the defendant didn't like trespassers, and they had issues. But a person of ordinary, reasonable temper, under all of those circumstances, would not be so enraged that they were compelled to walk outside, confront an unarmed person, and shoot them 6 times. An ordinary person would call the police.
Would that not be a factual question for the jury to consider?
Well, I guess my argument is if counsel had requested the instruction and the trial court had given it, and this had gone to the jury, the appellant essentially has to establish a reasonable probability that the jury would have bought this. They would have believed it after viewing the video, that he was either, acting in fear or self-defense, which they obviously rejected, or that he was so enraged by the victim's provocation that no ordinary person in those circumstances would have been able to just be calm and cool and not go murder someone. And so again, that is something, my argument is he hasn't established a reasonable probability that any juror would have found that. The fact that the jury did reject a self-defense claim, as the court in Newkirk stated, when a jury does reject a self-defense claim, it's highly unlikely that they're going to then rule in favor of a defendant on a suppression, on a sudden passion issue. Excuse me.
My last question kind of about this point, because I know we have 2 points to talk about and I don't want to take up all of your time, but has the state found, I guess this is kind of a different argument, because it is an instance where the court is presumably offering the defense counsel something that would be favorable to the defendant, and the defendant is saying, no, I don't want to take that. Does the state have any case law to support the fact that this, is not ineffective assistance of counsel?
Well, there are several cases where it's not ineffective assistance of counsel based on the fact that they either weren't entitled to it or they were entitled to it, but there wasn't prejudice because the jury wouldn't have bought it, which Newkirk is an example of one of those. If you're asking for examples where is there a legitimate trial strategy to not seek one? I didn't find anything regarding that. So, again, the record isn't developed to really show what counsel was thinking, other than that he seemed to think that his client wasn't entitled to it. So if the court doesn't have any other questions about that issue, I will try to briefly address consent. Just to reiterate what was in my brief, I think it's, again, this is another issue where the record is not developed enough for the appellant to be able to meet his burden. Even if counsel had filed a motion to suppress, there's really nothing in the record that would show that that would have been fruitful, because there's really nothing showing that consent was invalid. Ms. Hart not only gave verbal permission to enter, but she then signed 2 different consent forms. The one that was entered into the record, the Harris County Sheriff's Office consent form, is unlimited in scope. It authorizes a complete search and, excuse me, it authorizes a search of any materials or property that the police desired. The record indicates she had, plenty of time to look over it and read it. Deputy Silva testified that she asked her, or told Ms. Hart that if she had any questions about it to ask her, and she said that she didn't have any questions. She said that she understood the form. The form says that she wasn't threatened or promised anything. So really, it sounds like counsel's argument is that because she was so emotional, that rendered her incapable of providing, valid consent. Deputy Silva does testify that she wasn't, highly emotional at the time that she read the consent form. But even if we assume that she was extremely highly emotional under the stress of that traumatic event. The Court of Criminal Appeals has held in Lackey versus State that just the fact that a person is in a highly emotional state when they give consent is not going to render that consent involuntary.
It helps when I unmute. Is your position that there are no bounds to the consent? This moving away from her emotional state, that the form is enough to get anything and everything.
I mean, the form essentially states any materials and other property which the police desired. And notably, Ms. Hart never withdrew her consent at any point during the search. They're really, on the record, there's nothing else, any of the factors that would be considered that would suggest that she was too old. Yes, she had a cane, but if you watch the video of the incident, you can see her whack the defendant with her cane. So we're not talking about someone who's so ancient that they lack the mental wherewithal to be able to understand what they're signing. So given the fact that multiple consents were given on the basis of this record, the appellant just hasn't met his burden here. If there are no other questions, that will conclude the state's argument, and I'd ask that the conviction be affirmed. Thank you very much for your time.
Thank you, counsel. We'll start with rebuttal as soon as we get the screen switched over here. And the timer reset. There we go. All right, whenever you're ready.
Thank you, Your Honor. May it please the court, I'm Julia Bella. I'm here also for the appellant. I wanted to address some of the points that the state brought up. First, the claim that the argument regarding the failure to accept the trial court's offer of a sudden passion instruction. The appellant's brief cites that particular portion of the record verbatim, and it specifically indicates that the trial court had already developed a punishment charge. It had included a sudden passion instruction. Yes, he included just 4 proposals, but he was prepared to put that in. He expected that there would be a sudden passion instruction, which means he heard evidence that rose to the level that that would be required, at least a scintilla. There's much more than that, and the evidence that would support a sudden passion instruction is cited extensively in the appellant's brief and was cited extensively during the record testimony. And even just now, as the state made their argument, they brought up the fact that there was testimony that she had been abused in the past. There was an argument at the scene at the time of this incident. There was loud enough to where the people inside the home could hear them screaming at each other from the street. The surveillance video does not include sound, if I'm remembering correctly. So there is more than enough in the record and more than enough at trial to raise the evidence to the level where if defense counsel had simply said, yes, we are going to take that instruction, the trial court would have been fine. It would not have been an issue where the trial court was giving an instruction that wasn't warranted. Sudden passion was certainly raised by the evidence, and the trial judge knew it and offered him the instruction. There was no reason to turn that down. As far as the prejudice prong of Strickland, we're talking about an instruction that effectively reduced the possible exposure by 79 years on a murder conviction. I don't understand how it can't be prejudicial for a defendant to be looking at a possible sentence of 5 to 99 or life, and then have it reduced down to 2 to 20. It lowers both the floor and the ceiling and the exposure that the client faces, and there's no downside to accepting a sudden passion instruction, especially one that's already been offered by the trial court. We're not even raising a situation where defense counsel didn't ask for something. It didn't consider asking for something. We're talking about a situation where he was handed it to him. and turned it down. That's inexplicable. That does not comport with the standard of practice of criminal defense. This is ineffective assistance. The state is concerned that we have not elected which part of sudden passion we're contending should have been granted. That's not something that we're required to do. Sudden passion is an instruction that should have been given. And I'm sorry, Your Honor, I'm not sure if my time is up or if that's just from the reset.
No, I think your time's up. Go ahead and wrap it up.
As far as the consent, I would argue that based on what the state presented at their trial, one consent form instead of two, and the lone testimony of the deputy that had the second consent form, if that was what they had to support clear and convincing evidence, they fell woefully short. And if the defense attorney had raised that issue, the judge would have found in his favor. That is also effective assistance of counsel. So we'd ask that this be reversed for further proceedings.
Okay, thank you to all counsel for your arguments. Hart versus State is submitted, and we're adjourned.
Thank you, Your Honor.
Thank you, Your Honor. May I be excused?